attendance of the conference, but also to all the speakers. But we are already starting a little bit late, so let's get to it. The next panel will be very competitive because it will be on SEPs and competition law. We have a very good lineup here, and we are welcoming back Nina in a different capacity now from yesterday. That's why I'm doing the emceeing, because she's going to moderate today, twice actually. So please welcome Nina and her panelists, and I wish you an enjoyment and a successful panel.
Thank you very much for this nice walk-in. It's always a nice transition, the music. And now I'm very happy to be here and talk about SEPs and competition law with such a nice lineup. We all have heard different ideas on SEPs, contract, competition, and today we would really like to have a look and zoom in deeper from different perspectives. And I thought, given that you have the bios, speaker profiles, etc., on the web page, and that I always find it a bit repetitive to just read out what you already have read, I thought we start with a different intro, and I would ask my panelists, so in relation to competition law, how is that related to SEPs and FRAND, and what's your role in that? What was your story? And maybe that's a good point to introduce yourself with comparison to the topic. Let's start with you, Sophie.
Thank you so much, Nina. It's a pleasure to be here. Yes, sometimes when I come to these conferences, I feel a bit like a cuckoo in the nest because I am a competition lawyer, not a patent lawyer. Obviously, I share that characteristic with several others on the panel today. I think early in my career, I also felt that quite strongly because my firm, Bristow's, has a very large number of patent lawyers, and so I was frequently working with them to work out how competition law might play a role in IP disputes, not only FRAND disputes, but often including FRAND disputes. We were involved in one of the very early FRAND defences in the UK, very early in my career, and since then alongside a kind of competition law mandate, I've worked on patent cases involving the deployment of standard essential patents, working on both sides of the fence. Actually, I've acted both for implementers, typically patent holding implementers, but have also acted for patentees seeking to enforce their IP rights.
Thank you. First of all, a lot of thanks to WIPO and to Nina for inviting me today and for making the wonderful event happen. I'm Annie Xue, antitrust partner with Li Fang and Partners, a Beijing-based law firm. I actually got my antitrust training from the United States, which now has a very different ideology than my PhD days more than 10 years ago. And I started my career as an antitrust lawyer and have been intensively involved in almost all aspects of the interface between SEP and competition law cases. For example, from the SEP issues and relevant remedies in merger review, the antitrust investigation concerning SEP licensing, to antitrust litigation with SEP as a subject matter. So I would say competition law and the antitrust thinking will shed light on the understanding of FRAND, the power structure of the licensing landscape, how to set up the policy goals, and so forth. So that's my introduction. Thank you very much.
Yeah, my name is Anke Nestler, and to be honest, I have nothing to do directly with competition law because I'm the exotic here on this panel. I'm a valuation expert working for a very long time in valuation and IP licensing business. And well, the issue here is, and this is for sure, there's a reason that I'm sitting on that panel, that competition law prevents the company, the competitors, to talk about economic terms. And with relation to that, I think it's a very good opportunity to share them experiences I have as an expert to work on that side. And yes, for sure, as I'm in the market for quite a very long time, SEP licensing, front licensing and IP valuation is a very interesting and hot topic, and for sure I've worked on those in Germany already for quite some time.
So my name is Peter Kamasaska. It's very nice to be on this panel where we are now a selection of cuckoos and exotics, and it's nice to feel like I fit right in there. So I'm an antitrust lawyer, and as lawyers go, you go where your clients go. So about 15 years ago, a not-to-be-named largish Korean maker of phones started trundling towards what then became known as the smartphone wars. And as I was doing quite a bit of antitrust work for them, and there were antitrust components to that particular tussle they had to engage in, I got dragged into a system with that. And I think I learned two things. First of all, for antitrust, as for I think most of the work that we do in the SEP licensing phase, it's all about the money. So follow the money trail. And the money trail is often seen as a percentage of something. And the something was my second lesson in that particularly drawn-out affair, when a very learned judge asked about the basis for calculation. And of course, we had been arguing tooth and nail that a smartphone is really very different from a phone, and really a phone is, you can have a very high percentage royalty because the phone is only about connectivity, but a smartphone is so much more. And we were doing really, really well, and we had super experts. And I can tell you, a smartphone really is not a phone until some judge said so to our economic expert, not on this panel. So you are telling me that a smartphone is not a phone. So when your case needs some settlement coming up very quickly. And that's what got me into SEP licensing.
Great, thank you. I think now we also understood again how much intersections there are between contract law, competition law, economics. And I think different jurisdictions do have different approaches. We've heard that in the UK, for example, it's rather based on contract law these days, and still in Germany, the competition, the FRAND defense is still based mainly on competition law and interpreted in different ways. And also another big topic, I think, in the competition law area, a very topical one, is the approach to group licensing. And we do have a panel right after us, so we won't take all away, no worries, Hussein. Panelists will have something to say as well. But as we have quite some competition law experts from different jurisdictions, we would also like to have a look into this group licensing. Is licensing negotiation groups really a cartel? Are there pools that have different, are there obligation of pools in the FRAND area? And so I would say our panel is divided in these two bigger topics, like the FRAND defense in infringement cases in different jurisdictions, and then group licensing and antitrust. And as those are quite different, I would say we have our Q&A. I'm a fan of interactive panels, so I would encourage really to use the Mentimeter, but maybe only on the topic that we were just discussing, so that I can see the screen here, and I might ask my colleagues if it's getting too many questions, the screen is just too small, so that they will prompt me with some. But yeah, we definitely do have question answers to the first topic. And so let's start right away with the FRAND declaration. or the friend commitment, as it's also called, and that already gives a hint to the legal nature in a way, because a commitment is always or has already a bit of a hint to a contract, whereas a declaration seems to be rather neutral still and can also be seen as completely on a competition law basis. So is it a contract? Is it both? Has it a competition law prong? Has it a contract prong? Can they both go together? How does it look if there are different STOs with different applicable laws? Do we have then different contracts? Then maybe competition law still can provide another backup in a way. And what are the practical implications to that? And already mentioning Germany in this regard, I would start with our outsider on the other side. It's very nice to have actually so many women on this panel, I would say. So Peter, I'm very sorry, but here you're in the minority.
Oh, I'm not sorry about that at all. I like this. This is very nice.
Very good. So I would like to ask you, how does it look? Can you give us an overview first of the friend defense in Germany? Maybe what's the friend defense look like from the legal nature of the friend commitment, and also maybe some practical cases.
And of course, we're always totally spontaneous on these panels, so I would never say we had a plan, and now I'm going to go totally against that plan, because there's such a good question we already got. Someone in the audience said, shouldn't antitrust stay the hell away from, it was phrased nicer, from IP, because, it's just misadventures. Thank you for that question. Let me tell you why, in my unbridled arrogance, I think there is a role for antitrust, full stop, in SEP licensing. Because from my antitrust perspective, an SEP is born out of a cartel, okay? Because you've got a bunch of competitors in a room deciding what will be the standard. And that is why, from my antitrust perspective, there are these encumbrments, which is such a nice panel yesterday, where the judges were saying, it's normal IP, it's normal plus, it's not normal at all. It's very special for an antitrust lawyer. And so you're stuck with us because we'll keep nagging the IP lawyers that there are these special obligations. Now, what does that mean for the friend defense? Where does antitrust continentally come in? We're not concerned, and this is important to make that clear, about monopolies as such. Big is great, big is beautiful, we love it. It's how you exercise that monopoly power that may be an issue. And this is where all that you hear about, maybe unbridled injunctions are a problem, or how the friend, if it's not a friend rate. In my terminology, you call that exclusionary conduct. And so, we have guidance from the CJU. It's a little dated, meanwhile, it's about 10 years old, and it's the YYZTE dance, in our musical setting. I don't need to explain the dance passes that go with that, but that is really the basis of the friend defense. Now, I will argue that it's become a bit of a one-sided joke, meanwhile, over the last 10 years, the way how the friend defense has been interpreted on the continent. And here is how I get to that admittedly strong statement. So, first of all, we have at the end of last year, and it's really a cluster of cases that I would like to point to, and I'll do this quickly. We have the OLG in Munich, the higher regional court in the HMD Voice-H with its hearing, out of which it says that never mind what is said by the highest European court in YYZTE, we believe that there should be a mandatory security set by or paid in by the SEP implementer at essentially the height set by the SEP holder. Then, and with all due respect to the factuals that the judges of the local division of the UPC Mannheim had in front of them when they were gathering Panasonic OPEC, and I'm not saying that because certain judges are in this room, but it's important to have those factuals in mind. They say, well, we assume the infringement, and the top-down SEP holder offer with the facts in that case are sufficient. Doesn't have to be necessarily friend. I appreciate it's in that fact pattern, but now it's also a statement about how Huawei ZTE should be interpreted. We cascade down to Munich, where the local division UPC in Huawei Netgear says very much at the end of last year that the security should be set like the higher regional court has done in HMD, and by the way, no delays by the implementer, because in very great detail, you otherwise are very unwilling. And that brings us to what I would like to see as the present high water or low water mark. I think, Steve, you were very nice this morning by calling Judge Schön's Franthinweis as generating uncertainty and friction. I am maybe not so polite. I can't even say it's because I'm German, and we're blunt, you're that too. But I think Judge Schön's dancing skills on the floor on the Huawei ZTE tune are as follows. First of all, he thinks that the OLG, with its demand for security, I'll be very quick.
No.
1 minute.
No.
Oh.
I just wanted, because I'm not sure that because we have a global audience,
Yeah.
and maybe can you just very quickly say the friend defense is based on 102, so the Huawei ZTE was basically defining some steps, and just to give everyone in the room,
Right.
because if we go to Judge Schön in Munich, it might be a bit too quick. Just very briefly.
So there's a great German term, it's called a Fachidiot. So it's if you only live within your bubble as an EU antitrust lawyer, you suddenly assume that these precedents have a global impact. So 102 is our abuse of dominance antitrust rule as contained in the EU treaty. And all our national member states have a national interpretation of that. This is why I was also saying at the start that we're not concerned with dominance as such. There's only a problem if there's an abuse. And this is what Huawei ZTE, which is the big precedent on the applicability of 102 in the SEP licensing sphere, sets out a sort of stilted dance, which is what it's often referred to in a number of steps, who has to do what at which stage to avoid this abusive conduct coming up from either party. So, there has to be step one, a notification of the use of an SEP by the SEP holder. Then the SEP implementer, step two, has to voice willingness. Step three, a friend offer needs to be made by the holder. Step four, the implementer needs to accept it or come up with an argued counter offer. And if that all fails, at the end, you need to bring in someone grown up and come to terms. Now, what the case law development, and this brings us very quickly to Schön, has done, and what you can see in the previous precedents that I mentioned, is that in the judiciary, a lot of attention came down to the road towards friend, not friend as such, but how you get there. And that more often than not was a question of whether or not the implementer is willing. And we see that the emphasis on the willingness increases precedent by precedent, and the obligation on the SEP holder decreases step by step. So you can amend your offer all the time if you're a holder. Doesn't really have to be friend at the start. The EU wades in HMD, right, and says it's a sequential step, and you really need to be following Huawei ZTE. And the OLG in Munich says, well, I don't think so. And Judge Schön believes that this Huawei ZTE, and he literally says so in German, it's outdated. We're 10 years down the line, and I think, or Judge Schön says from his experience, here is how this SEP licensing in his court should be conducted. So he says, here are pointers that are really important. He says, for example, the OLG Munich does not go far enough with its demand for a security. Yes, there should be security, but in addition, the undisputed part of that needs to be paid straight away. If not, as the implementer, you are unwilling. So in many ways, Judge Schön goes back to the days before Huawei ZTE, where Orange Book really runs the roost, which actually led to Huawei ZTE. He also says the SEP holder can amend his or her offering to achieve FRANDness, doesn't need to be initially FRAND. However, the implementer, and he sets this out in great detail, needs to act quickly and decisively. If he doesn't do that, she does do that unwilling. Comparables, there are nearly half of the ruling, the Pfandhinweis is about the methodology. So there's a lot in there about comparables being the methodology of choice. And very important, Judge Schön says, well, in fact, in my court, I encourage high royalty payments in principle. So it's not so much about FRANDness, it's actually rewarding the invention by the SEP holder. Interim licenses. This is, of course, Judge Schön is a case in the wider Samsung ZTE tussle ongoing, where already there is a UK leg with interim licenses. So he says, well, you know, all our judges, we all do what we do. But if an interim license is enforced, no problem if a judge says we want an interim license, but if you actually then enforce it, that may be a sign of unwillingness. And so I think this really shows how, and this concludes the sort of where we are with this. I think it shows to me how hollowed out Huawei ZTE has become now, and how the EU really, as the guardian of EU law, right, faces a very tricky question, how it's going to put down its mark, because otherwise, like an obiter, Judge Schön's dancing skills will be setting the interpretation of Huawei ZTE for quite a while.
Yeah, thank you, Peter. I'm not sure whether because this judgment was raised quite a bit also in the coffee breaks. Is there anyone that has a question on that? Do I see questions? Maybe to my colleagues. I cannot see the screen. Can you scroll down a bit? No, nothing so far. I don't know. No. So that's actually then a great overview. I think just to also get back to everyone in the room. So in Germany, to sum up what Peter just said, it's still based on the idea that competition law and SEP is comes from a competition law scenario, because in an STO, of course, there need to be an IPR policy to make it not a cartel, but to have 101 basically kicking in. And then in the German law, 102 gives a certain, that's the TFEU, gives a certain dance. And this dance has now been interpreted differently by now most recently the Munich court. And I would then, Peter, I very quick, if
very quick, just one point.
Yeah?
If I had to choose the music to lead us on stage,
Yeah.
I would have suggested one of Schubert's Lieder, which is called Der Atlas.
Sorry, that was not a symphony, so we couldn't.
I know, but you know, that really depicts to me the burden that should be carried.
That's the problem. So basically, now we've heard Germany bases it very much on competition law 102 interpretation. One can really discuss very interesting topics. I would like to come to the UK because there is a very different approach, right? So and please also you can jump in at any time. I see the screen.
Thank you, Nina. So I think everyone knows, it's been mentioned, that despite my early forays into bringing Article 102 based defences to assertion of IP rights in cases that ultimately went unsettled, the UK now proceeds on a purely contractual basis, or at least it has done in all of the concluded cases about rate determination. Obviously, the fact that the UK will go on and do a rate determination is a different characteristic to many of the EU and German cases, and perhaps one that's a bit outside the scope of this discussion. But obviously, it does have resonances for why the UK perhaps doesn't see the pure competition law-based analysis to be quite so relevant. So, in brief terms, I think most of you are familiar with this, but the UK, from the case of Unwired Planet onwards, has been willing to deal with the FRAND defense by carrying out, basically seeking to interpret and then to apply the FRAND undertaking, the contract that has been entered into by holders of standard essential, ETSI standard essential patents. So there has been, for anyone who's interested, there's quite a lot of analysis in the case law of the French law implications of the wording of the contract, the ETSI contract being governed by French law, and in particular of the stipulation pour autrui, which is the part of that contract that gives rise to benefits for third parties making use of the standard. And so it's been established that those parties have a right to come to the English court, typically initially as defendants to a claim of patent infringement, but increasingly as claimants, saying this party holds standard essential patents in the UK, I wish to take a license, I undertake to take a license, and that is a requirement if coming to the court as an implementer. And please, court, would you determine what the terms of those licenses are? So that is a contractual basis. It works for ETSI. Query, we don't yet know fully whether it will work for other standards, because not all other standards have a clear third-party policy. So that may be a bit of a blind spot for the UK. Maybe there is then a residual role for competition-based infringement in those cases, but those are also not straightforward, particularly when it's sought to be established by an implementer. There was a case brought by Vestel a few years ago that fell down because they couldn't establish jurisdiction for a breach of competition law in the UK. So
may I just jump in, because I find it very interesting to also do the practical analysis between, so do we only talk about, like lawyers always like to talk about dogmatics, and what is it now, is it contract, is it competition law, but I would like to know, what does that mean actually? I mean, I understood from what Peter said, there are more conditions for competition law to kick in than for a contract. Can you maybe just elaborate how that is different?
Yes, so perhaps actually I come onto that by saying that although the English courts have sort of, in some ways it appears they've sidestepped competition law, but actually I do think there is quite a strong competition, maybe not competition law, but a competition policy theme that comes through the case law. So the design of the Frand injunction itself is designed to ensure that the patentee, which, we've talked about the fact that the standardization process involves competing companies coming together in circumstances which could allow them to block uptake by third parties. Obviously, there's a strong reason for encouraging that kind of innovation, as there is by individual patentees, but there's also a strong reason for the benefit of all to allow people to use those developments in order to create product innovation. And so the Frand injunction and undertaking, I think, is designed to embody that balance and to give effect to that balance. And I think that's discussed in part of the back. We talked about Huawei ZTE. Part of the background section to Huawei ZTE, before you get to the famous dance, talks about that the need that the court must strike a balance between maintaining free competition and the requirement to safeguard the proprietor's IP rights. And from a UK perspective, although in Unwired Planet we saw that the English court thought that the dance could be rather truncated, the parties only had to do the first step. They didn't need to carry on dancing after the patentee had made the notification to the implementer that it held standard essential patents. But notwithstanding that, I do think that sort of theme of balance between IP and competition, between implementers and patentees, is central to the way the English court approaches these things. The Supreme Court itself talked about the fact that the contractual modifications, I might say the contractual influence by competition law modifications to the general law of patents, are designed to achieve a fair balance between SEP holders and implementers. And that's quite a sort of strong resonance with what the Court of Justice said in Huawei. Competition law isn't actually fully ousted from consideration in the UK. I mean, we have our, we don't have the EU regime anymore, but we do still have the UK regime, which is directly modelled on the original EU rules. And there's been, in a number of cases, a recognition that if you had more serious sort of, or more extreme approaches being adopted, obviously competition law bites on the patentee rather than on the implementer, but if you have more extreme approaches being adopted, the court might still find that a rate was excessive for the purposes of competition law. Might be a question of whether that's actually problematic if they haven't granted or compelled someone to enter into a license at that rate. But there's still scope for excessive licensing, for non-discrimination, or for discrimination issues, and the like. I would say that, as I say, that the way that competition law is being applied, or perhaps in Peter's view, not so well applied in Europe, is to look at what comes before the grant of the license. As I say, the UK has been less interested in that aspect, and I do actually think that that's a bit of a blind spot. The English court says, well, you're going to be able to reach a point where we will determine the license, so in some ways what's gone before doesn't matter. But I do think that to avoid encouraging people to come to court too quickly, I think taking some due account of the appropriateness of negotiations in the run-up to licensing is important. Just a couple of very short final points on how competition law plays into these issues in the UK. I would say there's been no real activity by the CMA at any stage. Obviously, we see and we've heard very interestingly about the IPO consultation yesterday, and I noted that the representative of the IPO talked about consulting with patent colleagues around the world. I would encourage the IPO to consult with their competition colleagues as well. One thing that people may not be aware of, though, is that there is a case currently pending before the Competition Appeal Tribunal, where the Consumers Association of the UK is seeking redress on behalf of consumers against Qualcomm in relation to issues that will be familiar for those who followed the US litigation. So that is a case which is going to fall to be considered by a competition panel, so one of our lead competition judges, an economist, and I can't actually remember who the third panel member is, but it will be looked at through a competition framework. So competition law and SEPs is still alive in the UK.
That's very interesting to hear, because of course we always focus on the contract law point, and I found it also interesting that you made the point what has happening when there's not ETSI, because of course there's a stipulation pour autrui, so we have the contract, and maybe you can also have them both in parallel, right? You can maybe have a contractual, and I think Anke will also afterwards talk about, when we talk about money, what is happening, because we need a market abuse in competition law, and a contract technically does not need a market abuse. So there is a different approach. And I would like to now end our jurisdictional part with China, and I'm really very interested, how does it function in China? Is it a contract? Is it a defense? Do you also dance? Can you tell us a bit?
Sure.
Mm-hmm.
So just now, my German and British colleagues talk a lot about the case laws, but in China, actually we're not traditionally regarded as a case law country, so we do not have the case laws in the UK and the US sense. But in the past years, our court system, especially the Supreme People's Court, is trying very hard to improve our adjudication consistencies by ways, for instance, releasing guiding cases or representative cases and reference cases, and implementing so-called similar case retrieval system. So we do have quite some influential cases that are performing a very similar role to the case law in the UK and US sense. So getting back to the nature of Friend Declaration. So generally speaking, the Chinese courts do not heavily rely on the Friend Declaration very much, but rather look at the parties' negotiation behaviors through the lens of pre-contract obligation. That is to see, each party shall have the obligation to engage in good faith negotiation as required in the general rules of civil law and the contract law of China, which now have been incorporated into our civil code in 2020. But this good faith requirement is still enshrined in Article 7 of our civil code. So in the Huawei IDC case, the Shenzhen court held that there was no consensus on the interpretation of Friend Declaration across countries. So we are going to interpret the Friend principle, Friend Declaration, in accordance with the Chinese laws. So that's where the good faith negotiation requirements on both parties kick in. So from almost day one, so our like friend requirement or good faith negotiation requirement are imposed on both parties, not just the SEP holders or patent pools. In the Huawei and Samsung case, the Guangzhou court also look at friend as a negotiation principle that both parties should abide by. And later on in the IWN-COM versus Sony case, although the first instance court described friend declaration as an ex parte action, the appeal court, Beijing High Court, got back to the track of the good faith negotiation principle. So basically, the friend declaration is a more important consideration when it comes to the assessment of whether to release an injunction. In our judicial interpretation released by the Supreme Court about a patent dispute, an injunctive relief will be granted where a patent holder intentionally breach its friend commitment, leading to no license concluded, and the implementer has no obvious fault. Only kind of in this case, the injunction would be granted.
Great, Annie. Just to also being mindful of time, so I understand it's also a good faith negotiation.
Yeah.
That is basically also a bit what Germany and the Huawei ZTE is doing. It's not based on a competition law idea.
Here competition law comes.
But just I would also like to, just very briefly so that we can also move to the other
Sure.
and see.
Sure, very brief.
Yeah.
So the Chinese anti-monopoly law explicitly prohibits dominant market position holders' refusal to deal without justifications. So the implementing rules in the IP field, such as a departmental rule about the abuse of IP rights to exclude and restrict competition, and also our anti-monopoly guidelines for the IP field, and also our SEP antitrust guidance also sticks to this kind of prohibition, which means that the dominant market position holders actually in the SEP field, it's SEP holders or the patent pools, they should not refuse to license the SEPs without justifications. Yeah.
Interesting. Yeah, that brings us already, or sheds already a light to the pool topic. We will also briefly touch up on to set the scene for the following panel from the legal perspective. But let's now include our exotic member of the panel, as you saw yourself. I don't see that economists are in the friend game very exotic. I think you all belong to the part of the ecosystem. And I would like to know from you, so practically speaking, we talked about the legal nature, about the dance, and is it an academic law question? When it comes to the money, what do you see? What are the rates different in different jurisdictions? Because is there an abuse of dominance? Can that then be higher? How do you define, for example, the market? There are also different market definitions. That's also for the competition law lawyers, of course, but I think you work closely together when you define what is the relevant market. For example, there were also case law that raised quite some eyebrows with regard to market definitions. So can you just give us a short answer to the economic perspective, and then I think we can have a look at the question and move to our next topic. But Anke, please, the economist.
Okay, yeah. Well, for sure, competition law is very important for us from the economic side as a frame. I would like just to start with what we have in the friend determination itself. So, not so strongly focusing on the dispute side and case law, but more or less what we do from the economic side, and what should start in the negotiation in the beginning. So there must be always like a first discussion, negotiation between the patent owner and the patent licensees. And indeed, here is the question: what is the value of the technology? And here, I thought it's very interesting what Peter said with regard to the current views of the court in Munich. And here I would like to make a very important point from our economic point of view, beside any litigation, which is that a technology does not have a financial value itself. It's always the value that is created by using the technology. And if we have great inventors and they're sitting in a basement and they have a super good invention and they have a good filing of the patent and they are maybe closing the market if they would go to the market, but they don't do it, then the financial value of this patent would be theoretically the zero. So the same is when we look at the technologies here in the SEP environment, and the more markets and competitors and also other outside the usual smartphone market use this technology, well, the more value we see at the technology, because the licenses increase and the license royalty streams are higher. So this is what we see. So it's not as something that it's at a certain point of time we have to collect this value, but it's developing over time. So this is, well, also with regard to competition law, always the question, when is or might there be an abuse? It's not on me as a neutral expert to determine this, but for sure the question is for what was maybe a first contract agreed, and also for which products. And so we come to your question, Nina, how relevant are products and markets? For sure, if you have, for example, we talked also about substitution. If you have a typical smartphone and you say, okay, what is a substitution? Well, maybe a phone where you can make calls but without looking on screens or videos or something like that. I'm not really sure if this is really a fair substitution, and for that we have indeed a lot of comparables. And so we economists are doing the unpacking and packing and whatever we discussed in the session yesterday. But when we come to other products, then the question is, how do I use the technology in those products? And this is highly relevant for a fair pricing.
Great. Thank you, Anke. And I would really like to see some of the questions now. I think some we already answered. I saw something on Etsy and how no, go up, please. So, yeah, stop here. Etsy is a contract under French law. How does competition law come into the game? I think we already answered a bit. Very quick, very brief.
Well, I just wanted to add that the reason the contract is there, I think we've alluded to, is because of the fact it's an agreement between competitors and you need to ensure there's access for third parties. But I just wanted to remind people or make people aware that the EU did get involved in the crafting of that. So as in the European Commission, the competition wing of the European Commission got involved in the crafting of that contract. And in fact, issued the use of a most favoured nations clause in that context, which is sort of resonates with one of the things that was said on the SME panel earlier. So the contract, although it is now just a contract, but it has that competition law basis.
And then we had an interesting one for, Peter, you would like to just jump in very briefly here?
Mary, quickly, we focus a lot on the outcome of the Etsy process, but there's another competitional aspect, which is, how can it be run with those competitors in a room so that it's not a problem as such?
That's 101, right?
Yeah, exactly.
Yeah.
And I think, now we hear a lot of, back to our next topic, LNGs, how can it be compliant? Isn't that a boycott and stuff like that? We'll talk about that in a minute. But in many ways, Etsy is a really good example to show how, you bring competitors in a room, you put compliance measures on them, it functions very nicely. Long track record. And that's the 101 aspect. It shows how trade associations work, and it shows how this very complex SEP
I need
licensing
to cut you short.
isn't anything else than normal competition law.
Thank you so much. I just see so many questions. I would like to take another one. If implementer gain from FRAND pledges by SEP holders, what competition law duties bind them? For implementers, is FRAND not a shield or also an axe they can fall on? That's a very drastic one. So let's maybe very brief, the lawyers in the room from all jurisdictions. Quick, brief round, okay? But be brief, Peter, you first.
If you're unwilling there is nothing that stands between you and the acts of injunction, if you talk about the friend defense type background.
Yeah, I mean, the Fran dance involves the different steps. Each party has their obligations, although the implement is not bound in the same way by Article 102. If they don't comply with the steps, then they will fall short and be subject to an injunction. Obviously, whether that works in practice, people will have different views, but that's the idea.
The good faith, yeah, right.
Very quick. Yeah. To me, it looks like the competition law is a kind of allegation compared with the contract law, because in the contract law context, actually what is harmed is just a given market player or competitor. But the competition law, it protects competition. So if your unfriend or non-friend behaviors harms not just one competitor or one implementer, maybe the contract law is more relevant. And so it's a friend principles or commitment. But if you systematically, violate your friend commitment and harm the whole competition landscape, I think that's where the competition law kicks in.
Yeah, and I think the one thing about competition law that's important to remember is that ultimately it's about the consumer benefit. It's about wider markets operating effectively. That's what these safeguards are there to promote.
Okay, great. That was a very nice, quick round of answers. So let's already take the cue to go to our next big topic, which sets the scene for the group licensing coming after us. We've already heard LNGs. Are they cartels? How are pools bound by FRAND? And I would just like to raise that question. Is an LNG a cartel? Please all, one after the other. Quick.
Could be.
No, not as quick.
Well, we do what you tell us. If they, in principle, it's great. It's a negotiation tool. But just like Etsy, if these people would be fixing prices or stuff because there's competitors in a room, if they don't put in safety mechanisms, if they don't aggregate data, well, it's the risk of any trade association or any grouping of competitors. So you got to get those safeguards in there.
That will surely be a follow-up, which safeguards should be in there. But maybe Anke, next from your perspective, also practically speaking. Maybe?
Yeah, I think it's very interesting. Also, it's a different layer of competition law when we have like competitors not talking with each other, but coming to a joint conclusion about what is maybe a reasonable and fair license. And I made the experience, and it's not an LNG or SEP directly related topic, but when we work as a neutral expert in joint R&D, which means developing technology from big companies, and after they have a really ready-to-market product, they need to do like something like cross-licensing, and if they don't manage to discuss what is a fair and reasonable rate, then for sure nobody brings a product to the market, so they don't even ask the question, is it an SEP or not? They just need a license from each other. And this is a very interesting case where, for example, we acted as a neutral expert, putting up rules how to talk to us and not to talk to each other. We pooled the economic terms, and we agreed on the process. And so the whole process was like an arbitration expert. What I do in several occasions was managed by us as a neutral firm. And we were in a safeguard discussed by competition lawyers that we are on a safe ground. And the alternative would be everybody was sitting on a table, putting in the middle their envelopes, looking what's standing on there. Okay, the range was so broad, so they could not really come to a conclusion. And I think this is something very similar what we currently discuss with the LNGs, because here the competition law is on a different level. So I'm very optimistic that this might work here as well, but for sure then I have to ask the competition lawyers, in any case when we work as a neutral expert, what do we have to consider in that?
That was a very interesting one. So that went already in the measures. How is it in China? There were also some new developments. Maybe you can
very
shed
quick.
a light.
Yeah. So as you know, we have our antitrust authority has released the antitrust SEP guidance, but unfortunately, yes, it talks about the horizontal agreement, but basically from the point of view of SEP holders and also patent pools. So obviously, in their eyes, the horizontal agreement on the implementer side is not or has not been under their radar yet. But, with the rolling out of the ALNG in German, and which is endorsed by the EU Commission, now it's a hotly debated issue in China. So if we look at our anti-monopoly law, although normally we would think that the horizontal agreement between competitors is almost per se illegal conduct, but actually our Article 20 of the anti-monopoly law provides some exemptions of the application of the anti-monopoly law to horizontal agreement. And there are two possible scenarios under which the ALNG might, get a green light. One is that, if the purpose is to protect the legitimate interests in foreign trade or foreign economic cooperation, and the horizontal agreement participants, they can also prove that the impact or the damage to competition is not such severe, and they can pass on the benefit derived from the horizontal agreement to the ultimate consumers, then probably they can get approved from the authority. And coming back to the SEP scenario, so it's almost regarded as, falling into the scope of foreign trade or foreign economic cooperation, because a lot of patent holders, and especially the patent pools, they're foreign-based. And some Chinese industries got impacted by, certain non-friend behaviors. So that's one possibility. Another is that, if the technology improvement and the R&D for new product would be, protected by coming to a horizontal agreement, maybe it's also okay. But of course, the not very serious impact on competition and the pass on of the benefit to the consumers are also two very important requirements.
Great, thank you. I think that was very interesting, and I could to the two European lawyers. We had also some interesting topical matters that also relate to LNGs and pools. And maybe, being also mindful of time, you would also like to give a very quick view on the TTBR draft guidelines, and the consultation is ongoing. That was concerned the two of you. Peter, would you like to?
I'll do it quickly. So first of all, for a global audience, what is a TTBR,
yes.
a block exemption? A block exemption is a standard tool under European competition law which exempts, type agreements, frameworks, and so forth. What it really does, it's a tool on the one hand of regulatory efficiency. You don't need to clear every single patent pool or LNG again and again. We give you general guidance. We give you a general safe harbor, and I think for the implementers of such safe harbors, whether it's pools or LNGs, it gives you legal certainty if you stay within a framework. Now, we've had a tech transfer block exemption, anything about transferring technology, for quite a while. And the present one, these are not indefinite, they run for typically 10 years. The present one expires next April on 26th. So good regulatory due diligence. The EU will start market consultation. Should we keep this? If we keep it, how should it look like? And so forth. And that is typically a multi-year process, which is currently coming to its heat, where the Commission has very timely, with the WIPO conference in mind, issued a new text, how it should look like in the future. For our purposes, I think we should focus on two aspects. As you mentioned, patent pools and LNGs. I'll quickly do LNGs, and then maybe Sophie takes on the patent pools. It introduces, for the first time in the accompanying guidelines, the concept of an LNG. And I think that is really important in light of what I said before. It means that there is now a framework, if this actually becomes tech transfer block exemption renewed and new guidelines, under which conditions the EU believes that LNGs are in a safe harbor. 4 constituent elements, very quickly. If you are below 15% of the market, and the market could get Anke on a very long discourse about what is the relevant market, and right she is. And this was a big debate on the predecessor, if you want, the ALNG, which had to sort of cut make the trailblazer here. And it shows how important it is to get that right. What are we talking about product-wise and licensing-wise? Second condition, it needs to be an open structure. So just like we've seen in ALNG, it has to be open to other interested companies in the sector, manufacturers, component suppliers to join if they wish. The same is part of this new framework. Third condition, voluntary bilateral negotiations have to remain possible. This sounds very much like what we've already seen in patent pools on, quote unquote, the other side of the table. Negotiations are to be voluntary for the SEP holders, meaning that they should be free to be able to enter into negotiations, terminate those at any time. And finally, fourth condition, compliance. Exchanges of information for everyone in the room. In Europe, the cartel allegation is not just if you fix stuff, but also if you exchange sensitive information between the LNG members that must be limited to what is objectively necessary to conduct joint licensing. No commercially sensitive information should be shared between the members and so forth. And that is really new. But patent pools, well, we've had that for a while, but here also it's a very interesting review process that we've seen over the past 2 years.
Yes, I think the review on the patent pool side is obviously there was an existing set of guidelines on patent pools, and there's the tweaks. They are only tweaks that have been made to that. There's no significant revision to those, but there is a little bit of a change of emphasis in a few places. So, for example, previously there was a reference to the selection of independent experts. It's now been beefed up a little, so it now says that experts should be independent from the undertaking. So these are the experts who assess whether patents are genuinely essential before they go into a pool, because a pool will only be exempt if it only contains complementary patents or rights, not if it contains substitute rights. So, and the way that's tested is to see whether they are genuinely essential. And of course, experts come into that, technical experts. And so now the Commission has increased slightly the requirement that those experts should be truly independent of the pool that they're acting for. A couple of other points that the EU beefs up. It makes increased emphasis on the idea that those patents should also be valid, that some validity assessment needs to be done. And I think that is, again, the word was there before, but they've added a little bit more text, which suggests that is something they think is important. And the idea being that invalid IP rights will block innovation, and also the idea that it should be an ongoing assessment. And also, finally, just to note one other provision, that they now put an increased obligation on pools to make sure that people aren't being charged twice. So in other words, that they can, if they've taken a bilateral license to some of the rights in the pool, the licensee can effectively negotiate a reduced rate to reflect that they're already licensed for part of the rights in the pool. So no revolution in terms of pools. I think that on LNGs, that is clearly new. It's something that if people are interested and concerned, I see some of the comments on the slide that people are concerned that these arrangements could give rise to a sort of buyer cartel. I would say it's very normal for buyers to be able to collaborate when they occupy a small part of the market. That's true in all markets. You see it in the horizontal guidance. I think the concern is obviously, I can see a particular concern being raised about the automotive sector. I'm not going to comment on that in detail. Obviously, there's been a comfort letter given to the automotive pool, but I do think it does come down to this quite key issue of what the market is, because if you treat the market as being all users of the technology, including the auto companies, then clearly the auto companies are a very small part of that. But if you look at the automotive use alone, then I might hazard that BMW, Mercedes-Benz, Volkswagen, to the extent that they're not already part of the same group, which I think they might be, some of them, then they will perhaps form a larger part of that market, and therefore they would be well outside the sort of safe harbour that the EU recommends of 15%.
Yeah, that's I think very interesting, and that can also be a good cue to the next panel. And basically, so let's say it depends. There can be mechanisms for LNGs to, in your views, be not a cartel. And also on the pool side, there needs to be a certain mechanism followed. And when we have the competition lawyers and economists here, the market definition seems to be a very interesting one in this setting. With this, we do have another minute. So I have so many questions here. I would like to ask maybe my team to give me one that is particularly interesting, or because I cannot see them all. Or if you scroll slowly. Otherwise, I actually do have one to just do a final roundup. So we will hear about LNGs and pools, but let's say, to sum up, contract law, competition law. Just competition law, because we saw also, we talked in the judges panel, we heard there was India saying, or a case in India saying the competition law has actually nothing to do, and we saw also in some of the questions, why do we have competition laws there? So is there a role to play for competition law? And very brief, if so, what's the current role that you see?
I mean, for me, it's about access to markets. We heard a lot about the issues with SMEs earlier in the day, and I think I would like to see competition law doing more to do that. I don't think it's about punishing patent holders. I think sometimes people see competition law as coming in and sort of telling them not to do things. I would like to see it more about opening up markets, opening up innovation.
Yeah.
Mm-hmm. Okay, very simple from me. I would say the competition law comes in where there is a market failure.
Well, for sure, competition law is a frame where we economists have to work in. And as I said, it's in the end, it's all about money. And I believe that the current development we see in the discussion also about the LNGs will bring more transparency in the discussion, which was wished in several panels yesterday. So that's my statement.
I think from my side, my main observation would be it serves for IP and antitrust lawyers to really work together. I think there is such a clear interface between the two fields, and certainly in the area of SEPs, but also in the area of patent licensing, it does not go away. And I think we can do a lot more by, well, being not the cuckoos and exotics, but rather being integrated part of teams, whether it's an antitrust case that needs IP expertise or vice versa.
I think that was a very good overview, and we all are confident that competition law continues to play a role in this ecosystem on different areas. Thank you so much, my panelists. I think it was great. Sorry to the audience that had asked questions. I believe that they might be taken up in my next panel. So in our next panel, the next panel on group licensing. And thank you so much.